and thank you for your decades of ethical public service. I want to congratulate the organizers for putting on an outstanding program today. I don't know that there's a lot left for me to say, but I'm very glad that I was invited. It's a wonderful program that you've done, and I'm delighted to be participating in the 7th annual ethics seminar. One note of clarification, the subject of my presentation is tweaking, not twerking. I'm told that that's what Miley Cyrus did at a recent concert. I have witnessed some conduct over the years that would fit in well with her stage performance. Jim mentioned the legislature. I was going to get to that a little later, but since he brought it up, let me just start off by addressing the legislature. When I agreed to become the secretary for the second time, I thought, well, you know, I'm well prepared to do this. I've done it before. I know all about the multiple constituencies that the department has to please: developers, cities, counties, environmental groups, other public organizations, citizen groups. I didn't think a lot about the legislature. And the reason I think is because during my first term, 20 years earlier, the legislature was far different than it turned out to be during my second term. In fact, I can recall very few things about relations with individual legislators who in general were very supportive, respectful, eager to work with the department to implement the then new Growth Management Act. What I found though the second time around was something completely different. A completely different approach by legislators who were very aggressive in lobbying and pressuring state agencies to accommodate special interests, in particular development and business interests. So, after having sat down with one of the committee chairs who had jurisdiction over the Department of Community Affairs, and agreeing that we'd have a growth management bill that included things only that the department and its secretary would sign off on, I was called one day over to that legislator's office to discuss our bill, which had been drawn up and drafted and I had reviewed. When I walked into his office, I found the legislator and probably the leading top long-time lobbyist for the development interest, which took me a little bit by surprise. The legislator took out a sheet of paper and handed it to me, and it contained a lobbyist request for 20 additions to our Growth Management Act. I reviewed the list and respectfully informed the legislator that there's no way the department could support most of these things. He says, well, Mr. Secretary, I ask that you take this back with you, give careful thought to it, and see if you can accommodate the lobbyist, who, by the way, is the one in the room I have the most respect for. Well, I went back to my office. Staff reviewed the list of proposals, most of which were simply outrageous, very one-sided, special interest-oriented proposals. And I explained again to the legislator why the department simply could not support most of those things. I need them. Well, I understand, but we can't support them. I have constituents who want these things. I understand, but there's no way that the department can support most of these things. I am a senator and you're not. I said, I understand. I understand that you have to do what you have to do, but respectfully, the department cannot support most of these items. This meeting is over. That sort of set the tone for the legislature in my second term. I could give you a list of situations created by overzealous legislators attempting to influence the department on behalf of one of their constituents or special interest lobbyists. Very difficult to deal with those situations after all these people, have control over your budget and your legislation. And at that time, the department was undergoing a sunset review, which meant that it had to be reauthorized by the legislature or it would die. So we had to be especially careful about how we dealt with members of the legislature. Great delicacy, decorum, respect, the whole ball of wax. Most people don't realize that in 2010, the Senate passed a bill reauthorizing the Department of Community Affairs by a 38-0 vote. We have worked very, very hard in the legislature to get the department reauthorized, and that came out of the Senate. On the House side, 3 different House committees took up the issue, and each of those committees voted to reauthorize the department. But the then Speaker of the House would not allow that bill to come to a vote on the floor, because if he had, it would have passed, and a part of his agenda was to, frankly, dismantle or abolish the department. So this legislative angle threw a completely different wrench into what is always a delicate and a difficult process anyway. I haven't heard the legislature mentioned a lot today, but what the state legislature does affects all of us. It affects all local governments around the state. And we should, I think, give more consideration to what's going on up there. What happened in 2011 with the abolishment of the Department of Community Affairs and the gutting of the state's growth management and planning laws, I think probably if you applied ordinary ethical standards and values that we cherish in our democratic, with a little d, society, we would come to the conclusion that what happened there violated virtually every one of them. Because it was a closed door, not inclusive, a very unfair, one-sided process that allowed basically one industry to dictate what was going to be in the bill. And so that's what we have today. I just wanted to get the legislative thing out of the way before I move on. The temptations for unethical conduct today are huge. There's the corrosive impact of money, the influence of special interest lobbyists who raise untold millions of dollars for contributions and in return make millions of dollars. Based on reporting requirements, the 2 top lobbying firms in Florida during the last year at the top. And the complexity of many issues that can't be understood by an uninformed public make it very easy for well-heeled, well-financed, well-informed lobbyists to sort of rule the day in the legislature and elsewhere. How do we cope with and overcome these temptations? Well, I think we've heard a lot today that addresses that issue, and I'd sort of like to summarize and maybe put into my own words how I think we can and must do that. We must have a moral compass that is geared to the ethical values of a democratic, again with a little d, society. What are those ethical values? Well, during my almost 40 years of work in the public realm in some form or another, either as a private sector lawyer and planner or as a government official and employee, I've had the occasion to think about that. In fact, when I agreed to go back to the department the second time, I started by making a list of those things that I thought were very important and that I would like and hopefully would govern my second term at the Department of Community Affairs. It was based on lessons that I feel that I learned, hopefully, over the years, imperfectly, I know, but I came to believe were very, very important to an honest and just society and government. What are those lessons? Lesson number one, there are ethical values that are essential to good democratic government. In other words, they sort of form an ethical roadmap for our conduct. What are these values? First, integrity, honesty, and truthfulness. Transparency, openness, and accountability. Fairness and inclusiveness. Avoiding even the appearance of impropriety and conflict of interest and politically motivated decisions. These are values to live and work by, and if adhered to and respected and followed, will serve our state well and give us individual peace of mind. Lesson number two. The ethical tone of an agency is set at the top. I was very fortunate to work for two governors who not only let me and the agency I headed do the right thing, they insisted that we do the right thing. I was always impressed and very proud when they emphasized to agency heads in our agency head meetings that we had been hired to do the right thing for the people of Florida, that we were to obey the law and to take that message back to our staffs. In my experience, there is nothing more demoralizing to an agency staff than to have their work, their recommendations disregarded and without regard for the law and for obvious political reasons. I'll share one story with you when I was sort of on my way out of the department the second time. A controversy arose in the Green Swamp, one of Florida's designated areas of critical state concern. A person had decided that he was going to create a Wild Kingdom type development a la Disney in the Green Swamp. Without permits from the local government, he went out, started constructing buildings, etc. Was charged with stealing animals from the Tampa Zoo to put in his development. That came to the attention of the department's critical area staff, who carefully investigated the situation, researched the critical area rules, and came to me with a recommendation that this was in gross violation of the critical area rules. Because I was always reluctant to take enforcement action unless I was absolutely sure that it was warranted, I devoted my own personal time to carefully reviewing the regulations, the law, recommendation, all the facts, and I came to the conclusion that the staff was absolutely right, so we initiated enforcement action, which was appealed to the Florida governor and cabinet. I carefully explained to the governor and cabinet the work that the staff had done, the investigation that had taken place, the facts that we had uncovered, what the requirements were of the critical area, and gave them my word that I had personally reviewed and come to the conclusion that they were right. I certainly was qualified to give them that advice, being both a lawyer and a planner. I was astonished that following the plea from this developer to the cabinet to let him go forward, that a member of the cabinet, who's no longer on the cabinet, startled me by saying, I think the Department of Community Affairs has completely overreached. They're way out of line. They should get out of the way and let this man do his business. Well, I was floored, but not so much so that I could not respond as tactfully as I could by stating, it is demoralizing to agency staff to be criticized for doing the very work that the legislature and you, the governor and cabinet, have given them to do. It had a good outcome because that cabinet member then dropped his position on it, and the governor and cabinet proceeded to vote to uphold the enforcement action. But it is absolutely important that if we are going to serve the public interest, and that we are going to carry out, implement, and enforce laws that have been adopted by the legislature and rules that have been adopted by the governor and cabinet, that they get back up, that someone has their back. Lesson number 3. Integrity, honesty, and truthfulness are vital to an agency and its mission. Now, obviously, these 3 ethical values have a close relationship with each other. As the late Edward Murrow, who was a journalist noted for his high ethical standards, once said about his profession, to be persuasive, we must be believable. To be believable, we must be credible. To be credible, we must be truthful. Without these values, integrity, honesty, and truthfulness, any agency will lose its credibility and its mission eventually will fail. Lesson number 4. Government must be transparent, open, and accountable to the press, to the affected public, the agency's constituency, and to the general public. The agency's decision-making process should be carried out in public, and its decisions should be documented in the public records. And the agency should always be able to explain how and why its actions are legally defensible. And this means admitting mistakes when they are made. I was so surprised to experience a situation in which the department was excoriated in public by admitting a mistake. This was the situation. In reviewing a comprehensive plan amendment, department staff had recommended that it be found in compliance. That decision was challenged by citizens. And during the course of preparation for the final hearing, agency staff came to the conclusion that they had been wrong. The errors they had made were pointed out, and they were in a quandary as to what to do about it. What were they to say at hearing? Because they were informed that the citizens were going to subpoena them to appear at the hearing and give testimony, and they would be under oath. And so they came to me and said, what is it we're to do? I had no trouble in responding immediately, tell the truth. If we have made mistakes, if you have made mistakes, then you have to own up to them and confess them. So they proceeded to inform the other side, the attorneys for the local government and the landowner, that they had made a mistake and they would be reversing the position that they had previously taken in the forthcoming hearing. I could not believe the outrage from the attorney regarding the admission of a mistake. Government must always be willing to admit its mistakes when they discover that they have made them. There should also be assiduous adherence to the Government and the Sunshine Law and the Public Records Act. They were enacted so that we would have open government. I was so proud when one of the governors I worked for created an office of open government in the governor's office, required each of his agencies to appoint an open records officer, and required agencies to adopt policies which required them to make public records available within a short period of time. We have to honor those records, however difficult and irritating it might be sometimes. And I never understand it when I hear reports from the media that they are having difficulty in getting public records out of state executive agencies and government office, and I'm not pointing to any particular government or agency at this point, but that has occurred in the past. The bottom line is that a public agency should have nothing to hide, and it should not attempt to hide anything. The agency's business is the public's business. And I myself have experienced a situation where there have been attempts made to hide the evidence. And usually it just makes things worse And the ending is never good because it simply spurs the investigator, press or otherwise, on to get to the bottom of the situation. The agency's business is public business for the power to know. Lesson number 5. Avoid even the appearance of a conflict of interest in politically motivated decisions, that is, decisions not made in accordance with law, but they're made simply on the basis of politics. From personal experience, I can tell you that failure to do this can be very painful. Within my first 6 months at the department during my first tenure, I became the subject of a press investigation. And it resulted in part because of my own carelessness in dealing with the matter. Mail would come in every day to the secretary. I'd go through all the mail. We'd have tracking sheets, and I'd farm out things that had been sent to me to the appropriate unit within the department. One day, in my large packets, and they were always large, I found a very brief letter requesting something, noted, by the way, that it was sent in by my brother. I simply wrote a note on the cover of it that says, "Take care of this," and forwarded it on to the bureau chief who dealt with those kind of matters. That evolved to the situation where I was on the front page of the Tampa Tribune for 3 consecutive Sundays accusing me of unethical conduct and doing special favors for my brother. I was mortified. When it came out for the 3rd time, I simply was afraid to leave the house. I was so embarrassed that the thought of going out and fearing that everybody in my neighborhood had read the same headlines that I had read, it was an awful feeling. Ultimately, I was completely absolved. An ethics commission opinion was really requested. Nothing wrong or unethical was done. But I remembered that when I became secretary the 2nd time. And as a result, I was in a much better position to deal with a complaint filed with the Ethics Commission. And I would tell anybody who's ever served in public office that you're likely to be the target of an ethics complaint sooner or later. In this case, it turned out that immediately becoming secretary the 2nd time, remembering that very awful, painful incident before, I put into writing my recusal from any matter or decision that I had had anything to do with remotely or otherwise in the past. I instructed my lower staff, I delegated everything relating to that matter to them, instructed them never to communicate with me about it and to keep me completely in the dark, all of which was done. So when they came to me one day and said that there's someone who met with us today who's been making serious charges against you, one of his comments was, "I used to be a member of the military and I learned how to use guns and I still know how to use them, and we thought you should know about that." We put that into writing. Bottom line was, there simply was no ethics commission case, and we had documented everything, and we've taken the extra steps to make sure that I was removed and I was protected. We always have to go that extra step, that extra mile, if we are a public official, to avoid any hint that we are acting unethical. Lesson number 4 or 5, I forget. Don't be an enabler, initiator, or facilitator of unethical action. Disinformation and misinformation campaigns are awful, and in my view, completely unethical, whether we have any code of ethics that says it or not. And if you ever spend any time around the Florida legislature, you know what I'm talking about when I talk about disinformation and misinformation campaigns. Special interest lobbyists whispering in the ears of legislators, all kinds of nonsense, untruth, anything that will help them get their amendment passed. And I came to realize that these lobbyists were sort of like drug addicts who needed a fix. Mr. Secretary, I just need an amendment. Just a little amendment. You know, couldn't you help me with just a little amendment? it goes on, and there are, unfortunately, no established ethics in that arena, and misinformation and disinformation campaigns are the order of the day, unfortunately. Politicizing the decision-making process, going over the head of the agency decision-maker to the governor or the legislature. Clearly, there are certain times when an agency decision-maker has or may have made a wrong decision, or the law or agency policy is not clear, or what the right thing to do is not clear, and therefore it may be appropriate to have the decision reviewed by the higher authority. But all too frequently, this has become a way of doing business, a way of overruling meritorious agency decisions for political reasons and making lots of money for lobbyists. Don't become a victim of this process. You know, like lawyers like to say, every person, every entity is entitled to legal representation and a lawyer. That may be true, but it doesn't mean that you have to accept the representation because it will earn you lots of money when the objective is to gut laws and statutes enacted to protect the public interest, which again is exactly what I think happened in 2011 with our Growth Management Act. People who were just too willing to lend their names to that effort because they had their eye on the bottom line in their firm and how much money it was going to bring in, and how they might then get to represent developers after having helped gut these laws. Do not be an enabler of unethical action. So, to sum up, I know that your moral compasses have been tweaked a lot during today's program. Mine certainly has. I hope I've been able to tweak yours a little bit more. But I think the fact that you're here speaks so well of you and the organization which puts on this annual ethics seminar. And again, thank you very much for giving me the opportunity.